Welcome to Target UPSC. The topic for today's discussion is High Courts in India. The first High Court was established in 1862 and that were Calcutta, Madras and Bombay. Thereafter in 1866 the fourth High Court was established and that was Allahabad High Court. Right now we have 25 High Courts in India. Now let's see how judges of High Court been appointed. The judges of High Court been appointed by President. Please note down this point. The judges in High Court is appointed by President and not by Governor, and after consultation with Chief Justice of India and Governor of the corresponding state. Please note down this point. Though he is appointed by President of India, then what about the oath? So he is taking oath in front of Governor. So we can say, though he is appointed by the President, he should take oath before the Governor. That's the most important thing you need to understand. Now about the qualification. The qualification is nothing but, first one is he should be an Indian citizen. Second one, he should have held a judicial office in territory of India for 10 years, or he should have been advocate of High Court for 10 years. And these are the qualifications to be High Court judge. From here we can understand there is no minimum age to be High Court judge. Now about tenure of judges. First one, he hold office until he attained the age of 62. Any question regarding his age is to be decided by President after consultation with the Chief Justice of India, and the decision of the President will be final. And he can be removed from the office by the President on the recommendation of Parliament, and even he can resign from his post. The judge of High Court can resign from his post by writing to the President. Please note down this point. He can resign by writing it to the President, not to the Governor or Chief Justice of India. This is most important point. And we had discussed about the removal of High Court judge by the President on the recommendation of Parliament. Actually, this is not an easy process as it says, because the High Court judge can be removed from his office by an order of President. The President can issue the removal order only after an address by the Parliament has been presented to him in the same section for such removal. The address must be supported by a special majority of each House of Parliament, that is, majority of total membership of that House and majority of not less than 2/3 of members of that House present and voting. The grounds of removal are to proved misbehavior or incapacity. Thus, a judge of High Court can be removed in the same manner and on the same ground as a judge of Supreme Court. Please note down these points. Next thing is about ad hoc judges. You might heard about ad hoc judges, right? So Article 224A mention about ad hoc judges. Who are ad hoc judges? Any idea? Actually, ad hoc judges are retired judges and they can be reappointed by Chief Justice of High Court for any state at any time with previous consent of the President, and request any person who has held the office of judge of that court or of any other high court to sit and act as a judge of the high court for that state. And on 2014 we had seen a reformal activity take place in courts all over India, and it is called National Judicial Appointment Commission. This commission was been made in 2014 through 99 Constitution Amendment Act. The NJAC or National Judicial Appointment Commission proposed to make appointment of High Court and Supreme Court judges and Chief Justice more transparent. They will be selected by commission whose member will be drawn from the judiciary, legislature and civil society. The Constitutional Bench of Supreme Court declared NJAC as unconstitutional in 2015, citing that it violates basic structure of Indian Constitution. And this is all about High Courts in India.